Hi, good day, namaste, vanakkam, namaskar. I'm just thinking about uh, Supreme Court's newer consideration of whether divorce can be granted without both party consent. This Supreme Court is weighing. So it has fixed the date for September 28 for hearing. Probably this video also they can take into account if they see it in media. I consent to that. Uh, there is an omnibus uh, power under Article 142 of the Constitution for the past 26 years to annual irretrievably broken marriages. The Supreme Court today, Tuesday only, it agreed to examine whether it could grant divorce to estranged couples without both partners consenting to annulment of marriage. Um, I tell you a brief. Now, India has moved from days of reasons for marriage, and there is a little bit extra class added that makes a little bit easier, but still it's not up to many um, freer countries. I'll just check. Marriage is because in India marriage is recorded as a sacramental union under Hindu law, and even in Islamic law, and even in Christian law, everywhere it is same. There is no difference between being it considered as a sacramental union. Um, is it in Islam? It's a social institution where two individuals capable of entering into marriage pledge themselves to sustain and maintain the marital obligation. Social institution, that means it's like a free business or something. Same way in Hindu law, it is not saying like that. Sacrificed contract, so it affects other people also. So marriage is, although we say it's between two individuals, this relationship affects so many people around them and so many families around them. So it's not a single event, but the complication of religion and marriage for the last many centuries made the dissolution of the marriage, especially in Hindu Act. It was difficult in Islamic Act, although we say the talaq, three talaqs, and there was a big controversy there. So how is it really we want the government to make the institution of marriage? Can the government govern the principle, or religious relics govern the marriage, and can they protect the marriage from breaking away? In the freer world, many countries, many government, and many religious institutions found it impossible. That's why they relaxed the law. In India also, for Indian marriage, Hindu Marriage Act 1955 lays down three theories for the law of divorce, namely fault theory, breakdown theory, consent theory. So now we come to that. Under the fault theory, marriages can be dissolved only when either of the spouses had committed any matrimonial offences, and only the innocent party can seek the remedy of divorce under this theory. However, under no fault theory, the spouse asking for a divorce does not have to prove that the other spouse did something wrong or any matrimonial offense. This is a problem in a court. Each party they agreed to a contract. If a partnership in a company or a business breaks, would they both of them find a fault with the other and prove in the court and they break away? No, they just break away. If we consider the marriage as an institution, not only limited to the two people who are married, then we can understand. As long as in Hindu mythology, we were thinking like initially so many centuries old, you think people had been thinking like spouse as a possession, even Islamic, and they were thinking like it's like a possession. Women were deprived of their rights. Now, after understanding both sides, only so many changes occurred, and as mentioned earlier in the adult theory, marriage can be dissolved only when either the spouse had committed any matrimonial offense. It's necessary that one spouse has committed a matrimonial debt in that, and whereas the other spouse is absolutely an innocent party. Here the innocent spouse is considered to be as a victim. So it's like a victim claims that she is victimized, and he or she is given the liberty to break the marital tie by exercising the right of divorce against other spouse who is at fault by committing a matrimonial culpability. On the basis of theory, most of the ground, so you see many films and especially Indian films, Tamil films, there was big fight between them. Somebody wants to prove my wife did adultery or my husband made adultery. So it's no win situation. So far the partners were amicable, but this kind of fault theory makes them quarrel with each other, want to record each and everyone's activity, they spy on them. It's a big drama of sad events happening and spying events happening, and because the act lays down 9 grounds: adultery, cruelty. So if you want to prove cruelty, you just start a dialogue and wants other people to come and fight with you. You make them fight with you or the other person. So it's totally foolish thing. It lead them into adultery. You want to prove adultery, you want to that somebody can instigate the other person to go into adultery to prove. So it's dissertation. Somebody in anger they go away, and conversion to a religion. So for this reason, I know some male or female converted them into Hindu just to go for the divorce. Otherwise, the other person would not have granted them divorce. So incurable insanity or mental disorder. In court, people are fighting to prove the other person has mental. So this gives money to the lawyers. It prolongs the court proceedings. Thousands of cases are there, millions of cases are there to be solved because of this fault theory of divorce. Virulent and incurable leprosy, venereal disease, communicable form, sannyasa. Somebody is taking sannyasa. Seeing the other sannyasis, I want this to be taken out, because most of the sannyasis now they are in controversy. So just I'm joking. There is repudiation of world war by entering into a holy order, presumption of belief of death. Somebody died, he went to a war, we don't know what happened, and for 4 additional grounds on which wife alone can sue for divorce. So wife alone can sue, because adultery, having voluntary sexual intercourse with any person other than his or her spouse during the subsistence of marriage is termed as adultery. Adultery is a ground for divorce under the Hindu Marriages Act 1955, Special Marriages Act 1954, even a registered marriage. And section 497 of the Indian Penal Code, adultery was a criminal offence. This action has been struck down by the Supreme Court, Joseph Stein and Union of India, 2018. It's happened only in 2018, SC 4890. So when adultery is no more a criminal offence, it was not the in Hindu Marriages Act, it is not taken away still. So there remains some corrections or some modification to be taken up by Parliament for that. So desertion, somebody deserted, is they abandoned. According to section 13(1)(b) of the Hindu 1B of the Hindu Marriage Act 1950 is the essential condition of the offence of desertion in order that it might furnish a ground of relief, factum of separation, the intention to bring cohabitation, living together permanently to an end. So cruelty. So all these things, reasonable apprehension in petitioner's mind that it could be harmful or injurious for the petitioner to live with the other party, then it's referred to as cruelty. And no fault theory. Okay, now we talked fault divorce, and now no fault divorce, what is it and how the world, it is a change, a little bit change, but it changed quite a lot. No fault divorce refers to a form of divorce in which the petitioner need not have to prove any fault on the part of the other spouse. All a petitioner has to do is give any reason that is sufficient in the eyes of law for that. The most frequently given reason is irreconcilable differences or an irretrievable breakdown of a marriage, which basically means the couple do not get along and that the marital relationship cannot be fixed. The spouse cannot object another spouse's petition for no fault divorce, as that objection itself is regarded by the court as an irreconcilable difference. So section 13(1)(a), so how this can be applied in cases, we come to that. Section 13(1)(a) the Hindu Marriages Act 1955 contains the provision for irretrievable breakdown of marriage. It says that either party to a marriage may present a petition to the dissolution of the marriage by a decree of divorce on the ground: 1. That there has been no continuation of cohabitation as between the parties to the marriage for a period of not less than 1 year. If you are separated for 1 year upwards, it can be more. But the one writing clause here, after this 1 year is calculated after the passing of a decree for judicial separation in a proceedings to which they both were parties. So you go to a court and say we are separated, and then the court injuncts that from today you are considered not cohabiting, you are separate. From that day onwards 1 year has to pass, and within that 1 year they should not have come together. Okay. Or that there has been no restitution of conjugal rights as between the parties to the marriage for a period of not less than 1 year. So continuation of cohabitation, these living together, that there has been second part. If it is not there, there is no restitution of conjugal rights as between the parties to the marriage for a period of not less than 1 year or upward after the passing of a decree. So they, in this case, they can be outside or they can be inside, that doesn't matter. They don't have a conjugal right, they don't cohabit. It's not about cohabiting, it's they don't have a conjugal rights, and after passing that decree by the court, then only the time starts, and after 1 year they will be given, if they still are like that, whatever the rules in the decree, if they got that, then the absolute divorce will be granted. And it can also be obtained on the basis of no fault theory, which means the divorce can be obtained by mutual consent. This is like a mutual consent of the parties to marry, and under the Marriage Laws Act Amendment 1976. According to section 138(1) of the Hindu Marriage Act 1955, such petition is required to be moved mutually by both parties on the ground that they have been living separately for a period of not less than 1 year or more, and they do not want to live together, and also that they have mutually agreed that marriage should be dissolved. So I am coming to a problem here where either you go for divorce, finding fault with others, or if you mutually consent, then after 1 year, after going to the court, you can get the divorce. What if only one party wants divorce, the other party doesn't want divorce? What will happen? So this is where we have to look back into the institution of marriage as we have in our belief about Indian. I'm not talking only about Hindu, Muslim, Christian, any religion here in India, how it takes marriage and how the Western countries take the marriage. So if the marriage is considered just between husband and wife, then it's easy, but it's not, because it involves so many other. So people take dowry in Western Western civilization. There is no dowry involved, or they can bring some. I mean, it's not considered part and parcel of the marriage, and so in West they give and there are some they solve the problem in easier methods. How? First, divorce. So we separate. So what is the problem in a divorce? Divorce, one party is affected maybe financially. Second, one party may be earning, the other party may not be earning. And even if both the parties are earning, their income is not proportional. I mean, they may be unequally earning. At the time when the marriage is there, their financial stability is easy. If they are separated, the other person has to take another home. He has to his all costs are. So when divorce is granted, the main problem is about financial. So far, before women took up jobs, Indian tradition is husband was earning and women were doing the family chores at our home, and that was the easier way at that time. Now both the couple go for jobs and both are earning. Nowadays it's almost equal, so everything changed now. So the first part of the problem is about finances. So Indian courts have been the compensation for the other party. If one is at fault, we consider the one party at fault. One party at fault, the other party will get a compensation. Not only that, what about children? So now the problem of children. Who will take care of the children? This is another equation in that. So they want to go together initially for the marriage. If they want to break, what will happen to the children? Normally, not only in India, many parts of the world, children, the women, because of their, they give birth and they know better, and that is the judgment normally going in. So they want to take care of the children. What about the upbringing of the children? What about the cost for them? Maintenance. India also, they say maintenance has to be given. So for considering all these things, the income is taken, pulled together. So in West, it's easier now. What they say, there are two kind of states. One kind of state say, whatever your income, whatever your properties, and whatever your spouse's property, if you come in relationship, it is common property. Whatever income after that you earn, whatever you do, it's a common property. It has to be divided based on circumstances. In Australia, it is based on circumstances. It is not, there is no automatic division. It is based on circumstances. If the marriage is only 2-year old, what will you do? What will you do? If the marriage is 10-year old, what will you do? So more and more they are dependent on each other. Breaking takes a lot of, it's like a pie. They just consider this as a real business partnership. So there is, it's very easy. A break, make somebody with somebody has to lose money, somebody may gain, or if both are equally earning, it's equally share. I mean, mostly it won't be. Mostly in Australia, women get 60, 70, 80% of the share, and maintenance also till the children get to certain age. For example, 18 years, they have to, the husband has to take care of some part of the maintenance, so you'll be earning, all money is going to the other party. So divorce is avoided mostly if possible because of the financial problems. But women nowadays here, they tend to apply for divorce, and because their financial guarantee is there, the government makes sure the other spouse gives for the maintenance of the children, and if the lady is not working, probably she also gets some maintenance. So financially, if it is beneficial, then they go for. So right, but the one big plus point is in Australia. Consider Australia. For I'm just coming for the mutual divorce or non-mutual divorce. So in Australia, I don't need to, nobody needs to prove anybody adultery, all those things. In 1975, no clause was required. It's changed now to split. Although adultery is not a fault, all those things went now. No fault divorce has come into and in that 12 months of separation, as India did, same thing. That only one problem there is, the government need not, the courts need not give a decree for the separation. If one of the spouse, one of the couple send an application saying we are separate for 12 months, the other party says, and the notice only has to be given to the other person. If the notice is served, it's like automatic. After certain days, 42 days, 21 days, the court case comes in. So the both parties, whether they come or not, the divorce is granted. That's it. So no decree. So the major problem in India I'm seeing is, first, both the couple have to go to the court to apply for mutual consent. If other party is not signing, so the other party has to take the fault divorce route. To avoid that, in Australia, if we want to make this, not mutual consent. Only either of the party can apply for for no fault divorce. I request the Supreme Court as well as the Supreme Court, because it's now it's considering, it can recommend to the Parliament to include a law that should make no fault, that could include another clause in the no fault divorce, no need for any consent by both. Only single party, each party can file a divorce without finding fault. No fault divorce can be applied by either of the party. It need not get the consent of the other party. If they file a petition, the only consideration for the courts or to see whether they are separated. I'm not talking about either conjugal right or physical separation or both. That's up to them. If they think 12 months they are not living together in a house, or they don't have conjugal, they don't exercise conjugal rights, they should be granted divorce automatically. So court's time will be very easy. So they can, divorce can be granted easily because the couple are already staying away for 12 months. Why should court or government intervene and force certain thing that is not possible? So if they are separate already and no conjugal right, it can be granted. The one problem here is how to prove. They don't need to prove in court. Only if the other party contends that no, I was also living with them, then problem comes. If they are separated already, no problem. The other party has to prove. So a wife, for example, a wife is filing a no fault divorce and the husband is not staying with her for 12 months, and if the husband wants to contest that, he can contest on the time limit, I mean the legal time limit for serving notice, all those things. That's not the biggest obstacle. But if he wants to prove that he was staying with her, he has to provide evidence. So the onus is on the other party. So this makes the divorce less complicated, and the mutual consent clause is a problem. So what happens if somebody is away for 6 months but still they want to force a divorce? In that case, in Australia they say you have to have a legal counsel, I mean mediation. You have to attend a mediation seminar. So in case a quick divorce is requested, then that is with before 12-month period of separation, then also they can that also it's not binding. Their duty is just to give legal opinion about how you'll suffer, what about your children, what about. So first we consider only divorce can be granted, that can be separated from. So the other problems in Indian courts is too much complication about divorce and maintenance and this and that. Take divorce as a separate issue. Divorce, 12 months separation, either party can apply, and if the other party can't prove that within the 12, I mean the statement is wrong. If he says I was with her for 6 months, the court will listen to the hearings and hear the hearings. So in that case, the other party has to prove that he was with them 6 months. In that case also nothing gone. So the other party can wait for another 6 months and file petition. So legal cost will be very low. It will be, the lawyers will have the happiness of solving the problems quickly, rather than, under the current circumstances, it is not in their hands to uh, serve their client properly. Now the lawyers will find it very, very very easy to implement this. So this is the change we want. So what about, so the second thing is about maintenance. It that will be a separate petition. Once divorce is granted, they can file both, but it can be heard separately. This one separate, divorce granted. This is a just a procedural, this one. So how to divide the property, how to give maintenance, all those things. Each one has to file their uh, their asset or their income on that day. The other person also. We have to make it very penal, criminal offense if somebody is hiding some facts in that. So the criminality of that, anything that is hidden, anything is stated untruthfully, it has to that party will have to go to my recommendation is to go to at least 1 year of imprisonment, so that to avoid the false declarations about their income and properties. And the third one is about the children. What are the costs? Who has to maintain? That is not related to the divorce. The court has to take it separately. Otherwise, long pending cases. All the time the divorce cases are not solved. So three things separate: finance, children, divorce. Divorce first can be taken up because it will be made as a legal. And I totally recommend to the Supreme Court. I am not a legal professional. That is why I can do anything. So I am not bound by. I am a consumer. It happened in my families. I went to the court for other people, just as a representing them in a private capacity. Many cases in Australia as well as India. So I know the intricacies of them. So by experience, I tell, just please take away the fault divorce. That will make people at least see each other like before, like business separation. But only we should have, so in Islam, Christian and Hindu, all acts should remove the faulty divorce rule. So in that case, this cruelty, all those things, just remove all those things. Proving in the court, it takes a lot of our time. So just we want to keep no faulty continuation. So the current form with consent, it can remain. The third form without consent, no fault divorce, either party, or we can just change the entire thing. No fault divorce, either party can apply. No consent is required. So this will change the marriage and divorces, and everything in the marriage will be truthful, not bound by the circumstances, not bound by the rules and regulations. And the divorces cannot prolong, and everything is simple. The affected parties can remarry quickly. They can find another life. So this will be the easiest option. I totally plead the Supreme Court as well as the Government of India to change the rules to apply no fault theory of divorce based on one party application. It need not be consent with the other party's consent, and they have to treat divorce separate, financial separate, and the child care separate. In the financial and child, the statement, the worth given with statement should be signed by signed witnessed by notary public, and there is a binding statement. If anything false stated there, 1 year of imprisonment for either party, so that makes it truthful. So we just go by that. Our marriage laws are totally modified. That will be happy situation for Indian marriage law. Thank you. I am Natarajan S. I live in Sydney. Thank you. Anything you want, you can write to me in my YouTube. I'll just see that and answer you. Thank you so much.